Pigeon was found carrying a small backpack filled with crystal meth last week at the Pacific Institution in Abbotsford. The correctional facility staff says the bird was spotted with its bag of drugs in the yard on December 29th, and officers set up a trap to catch it. They say they're always on the lookout for drones, but this is the first time they've encountered a pigeon drug smuggler. The warden has confirmed a recent interception of contraband and says the Pacific Institution is now investigating.
Testimony about to give this the truth, the whole truth, and nothing but the truth.
Yes, I do.
All right, thank you. You may proceed on the warrant.
On March 30th, 2023, at approximately 1:08 a.m., Officers Gardaki and staff that were riding a double car when they observed a vehicle driven by Maldonado with a completely unreadable license plate. Officers made a traffic stop on the vehicle in the area of North Line and 4th Street. While speaking with Maldonado, who was the driver and sole occupant of the vehicle, he advised Officer Stathakis that the license plate was improper as it belonged on another vehicle. Officer Stathakis asked for it and was given consent by Maldonado to search his vehicle. During the search, the following items were recovered: a Walmart grocery bag on the front passenger floor that contained an electronic scale with a copious amount of cocaine residue, a clear plastic baggie containing 2 lottery tickets that contained fentanyl. Also behind the driver's seat was a half-empty 750 milliliter bottle of Patron Silver tequila. While speaking with Maldonado, he advised Officer Stathakis that the lottery contained boy, which is a drug slang for heroin. The powder in the lottery tickets was field tested positively fentanyl by Officer Stathakis, who also tested the powder on a scale which tested positively cocaine. The weight of fentanyl was 0.4 grams. Nothing further.
Thank you. On examination of the complaining witness, I find the offensive charge were committed. There's probable cause to believe that defendant committed those offenses. And good morning, counsel. Your appearance, please.
Good morning, Your Honor. Christopher Shumke appearing on behalf of my client. At this time, we consent to the matter being heard via Zoom. As to arraignment, we waive formal reading. My client stands me.
All right, thank you. And Mr. Maldonado, your name, please.
Richard Maldonado.
All right, thank you. And I'm sorry, counsel, you indicated waive formal reading, correct?
Yes, Your Honor.
All right, the court's going to waive the formal reading. Sir, you have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And in fact, you've had an opportunity to speak to an attorney today, correct?
Yes, I did.
All right, and the
There
court
we
has also
go.
signed a request for appointment of attorney for felony matters.
Stephanie!
And sir, you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the
Here
right to
now.
a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes.
All right, the court's going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on April 6th at 9 a.m. And counsel as to bond, and then I'll give the sergeant an opportunity to address bond.
Yes, Your Honor, I'm positive. My client is gainfully employed. He works for the Postal Service. He does full-time. He is the father of a 9-month-old child. He's not on probation.
Okay, so what I was saying was, how we doing, everybody? TGI, time served. How we doing? Take 2. I got St. John Part 2 in the house. Much waited. How we doing, everybody? Let's have some fun. Thank you, Stephanie. 10 gifted memberships. We're going to have 10 members of the time served Army right off the bat. Let's get it rolling with some classic Sally Port style wind-up. Let's roll.
Or parole. The judge indicates he will appear at any and all future court dates. We'd respectfully request any leniency when determining the appropriate bond. Thank you, Your Honor.
Thank you. And Sergeant Fitzpatrick, as to your request for bond.
Oh, Your Honor, I was contacted yesterday by APA Gailey in the Wayne County Prosecutor's Office to advise that Maldonado has other pending issues that he's aware of. Further, the defendant had nearly $5,000 in cash on him at the time of his arrest. Due to the nature of the offense, as well as the habitual fourth attachment to the warrant, and the fact that the defendant has multiple open warrants for his arrest right now, and apparently access to large amounts of cash, I believe a $100,000 10% bond may be appropriate in this matter.
Okay. And Mr. Maldonado?
Yes, I'm being evicted, as of today, March 31st from my house. So the money is for my down payment for a new house. I just got my bank account. I think it shows the money being taken out of my bank account because I'm being evicted today, actually, for the house. So that's why the money's there. I just got my income tax check like 3 weeks ago for $3,500 cash. I'm gonna get a new apartment building. Supposedly today, I'm getting evicted today. 7-day eviction notice from today. It's due today. So, I mean, I have a couple of warrants for traffic in Detroit, and like I put it, there's 3 traffic tickets. Like, I can easily get those taken care of. And that's why I had that money. I was going to get an apartment yesterday, well, 2 days ago, $2,000 down payment and $2,000 in the second part, $4,000.
And sir, where was that apartment?
The new one, it didn't fall through, but the apartment I'm getting evicted from is 1380 Riverbank. I got the,
No.
yeah, the apartment,
No.
yeah, didn't go through.
The apartment that you're getting.
The rental is on Central and Verner in Detroit, but they took my application down, but they said there's no apartments available for 30 days. On Central and Verner.
Motor
in the
mouth.
high rise.
Hold on, because this Zoom stopped for a moment.
Sure it did.
I don't know if you can hear me or not. I'm not sure, but can you hear me or no? Mr. Sunke, can you hear me?
I can hear you.
Okay, well, I can't see anybody and it shows it's connecting, so I don't even know if we're recording, so we have to take a break for a moment.
I need to see Miss DeSanto. I'm sorry. I can't have audio of her. I need both.
Correct?
That's what it's supposed to be.
Hold on, the Zoom went down again, just one moment.
Yes.
Hold on. The Zoom went out again. You know she's ripping heads for that one. Heads are flying for this Zoom problem. She's no Judge Middleton, I'll tell you that much. What's up, everybody? What up, Monica? Michelle, Laura, Electric Head Gino. That's a new one.
So let's try this again.
Welcome.
Okay, so you were on your way to go meet somebody, perhaps, for the night visit?
Well, the day had already ended, so I was working on getting an apartment all day through the places, so I was getting my money there, and then it became 2 o'clock, it's time for me to go to UPS. I work at UPS between 3 a.m. to like 9 a.m. roughly.
Don't look at the defendant. Look at DeSanto. Don't look at, just look at her.
So I was going towards that way at 1 a.m. So the day had already ended, so I was trying all day to get the apartment, so no one would let me move in right away. I need to move in like today, like 2 days. I'm getting all my stuff being put out today. So I'm trying to go in there and just give my money up however possible. I buy $4,000 cash, all the money I have to my name. So once you guys take that money, I can't even bond out pretty much. That bond is super high. I mean,
Hold on,
that's the.
sir, hold on. You said that the apartment's at Central and Berner, but then you can't get in for 30 more days.
Right, I bought the application, so my mom told me that you go into the application, you have the first down payment, which I thought that would be, I go into my money and show my work and stuff, but it's not even available for another 30 days minimum, they said, 30 to 45 days at that particular apartment building. I already have 3 other ones lined up, and I can't just stop there, I can't wait 30 days for a place, can't wait, I gotta go within 7 days, this is my 7th day right here, so I'm in trouble now.
Hold on, sir, stop. Because you're talking in circles, quite honestly, because you said that you have money for a down payment, but you don't even know where this down payment is going.
Exactly, I don't even have a property picked out yet. I had 3 that was lined up because I had to be out.
So you want this court to believe that you're just walking around, driving around, or whatever it was, it's $4,100 to put down some down payment at a place you just happen to find.
Well, I can show you my bank account. I took out $1,020 from Bank of America. I can show you on my phone yesterday. I emptied the bank account completely out there at Bank of America. And then the other bank check was my $3,500 from my income tax check that I just received 3 weeks ago.
Your Honor, if I may, the actual dollar amount was $4,714.
Was it?
That's right.
I'm not even sure. So, I mean,
Was it?
that's what it was, Judge.
And so where the warrants, Detective Sergeant, where are those warrants out of?
36th District. I'm unaware of the specifics of what APA Gailey was speaking about yesterday.
Bryant territory.
Traffic ticket. Unpaid traffic ticket.
Well, and you have a restricted license, correct, sir?
Yeah, for work only.
And where is it you work?
United Postal Service on 19951 Hoover Street, Detroit.
UPS, not the post office, UPS.
Yeah, United Postal Service, yes, UPS. I'm a package unloader and loader, sorter.
And what's your work schedule?
I work Tuesday through Saturday, and sometimes on Monday, 3 a.m. to 9:30 a.m. roughly. $18 an hour.
Lying.
So you only work the one job?
Yeah.
Those part-time, right?
Yeah, about 25 to 30 hours a week.
Well, there seems to be a lot of, warrant requests regarding various jurisdictions. And you're not on probation or parole anywhere, sir?
Oh, ma'am. The warrants
What
in
about your matter?
Detroit.
Excuse me, what about your matter out of Oakland County that you were just sentenced in December of 2020?
What is that?
You served 6 months jail, or 4 months
Yeah,
jail.
that was a mistake, yeah. I was time served.
What's that?
Yeah. For a time served incident, I already did that time, and they called me back there on a mistake, for Oakland County.
It was what?
Thirty-sixth
And
District,
so
he has,
I'm sorry, what was that?
36th District, he has 4 cases there, on the outstanding balances. Between the 4 of them, they're combined to $200. So it looks like it is civil action, not he has in case 2.
Okay, I only got part of that because it was breaking up very badly. I don't know if it's
Uh,
on
just-
it's probably on this end.
They're civil infractions. That's the 36th district. I just looked them up.
Okay. And how old are those warrants, counsel?
From 2022.
All right. And, sir, where is your work located?
19951 Hoover Street, Detroit. I believe it's like Hamtramck, but Hoover.
Well, so you didn't fill out your address on here.
I don't really technically have one because I'm getting evicted today. So I use my mom's address as my 2440 Lawndale, Detroit, Michigan. That's the address.
Yeah,
I'm
and so
happy-
what street do you live on?
Right now, I stay on 1380 Riverbank until today. In Lincoln Park.
And what city is that?
Lincoln Park, like on 4th Street and Emmons are right there. But like I said, I got served an eviction notice 7 days ago, and it says for March 31st, so let's see how that goes. I don't know if they can do that to me, just tell me 2 weeks, I have to leave, in 2 weeks. I'm not even sure that's possible, so I have to see that. Because the owner
Did
sells
you
the
have
house.
written proof? Did you have written proof of your destination hours with you, sir?
Of my what?
Did you have proof on you regarding your destination to work?
Oh, I got my time schedule, that's about it. My schedule starts at 3 a.m., 3:30 a.m. for this week.
Well, it appears as though you weren't quite following the restrictions of your license either. So the court's going to indicate, based upon the defendant's criminal history, the charges that he has, the warrants that he has out, and the habitual offender fourth offense notice. You're looking for tissue? I think there's. The court's going to indicate $100,000, 10% bond.
There's no way I can pay that bond, Judge.
In the event you post bond, you have to possess or consume any alcohol or drugs that are not prescribed.
The judge,
And
no way,
you
there's no ministry on
already
that,
have a
Judge?
you already have a GPS tether. I'm sorry, what was that?
There's no way, no leniency on that bond is just too high. There's no way I'll be able to post that bond.
Well, sir, given the fact that you're looking at habitual offender fourth offense potential, with, significantly enhanced sentence, the court has some concerns. The court also has concerns that you don't have a stable place to live. At this point, the court is also concerned that you have warrants out for your arrest you have not handled, and that the court wants to make sure you're going to be appearing in court. So, there we go.
Hi, Judge.
Thank you, Your Honor.
With that,
Thank you.
all right, thank you, have a good day. All right, we're going off the record for a moment.
If you qualify.
So I got this one today, and you think you had a bad day or a bad week? Listen to my man Mick Carroll. He's really M. Carroll, but I call him Mick Carroll. Here we go.
You can receive the assistance of an attorney to help effectuate resolution of this case.
I don't think I need one because I have the money to pay. I just was late because I had two emergencies back to back. The first one, I was expecting to get my retainer back from Navigate Law Firm in Vancouver, and they bounced a check on me for $1,800. I've never bounced a check before, but when you bounce a check for $1,800, I can't pay my bills. I can't do anything until the bank is paid. So I had to pay Red Canoe back their money. And then the following month, this month, I get in a car accident on I-5. A dump truck flipped over in front of me and totaled my car. And then I had to pay to have my car towed to Vancouver to the service center. And then I didn't have a car for 5 days till that rental insurance gave me a car. So I lost 5 days of wages.
Okay, so Mr. Carroll, so I'll ask you,
What up, Robert?
so what I can
What up,
do, I
Smoochie?
will allow you more time to work directly with the
Tessa.
attorney for the landlord.
Okay,
So if I give you 2 weeks to contact Ms. Winkle's office, would he be contacting you,
I tried
Mr.?
it, Your Honor,
Hold
I
on a
tried, oh,
Mr. Carroll, I'm speaking. Ms. Sturm, would he be contacting your office or Ms. Winkle's?
Miss Winkle's office.
Okay, so what I'm going to do, I'm going to ask you one more time whether you're requesting an attorney to assist in this case, and is the answer no to that, Mr. Carroll?
I'm not sure, do I need one? Because I'm not fighting anybody for anything. I just want to pay my rent. And my
Yeah.
back rent. I'm not contesting anything.
Go ahead, Ms. Sturm.
Yeah, I think, as far as I know, I think that the plaintiff would like,
I thought this other lady to the right of Mick Carroll was writing a note, and she was like kidnapped, and she was like in a closet somewhere. She was trying to like send a note to us on Zoom.
proceed today. Rent's not been paid. I think service was timely. We're here today. It's still not paid. I think we'd asked to proceed today.
Okay,
Yeah, I want to pay my rent today. I want to pay it.
Yeah.
I was going to pay it last week, but Miss Winkle
Mr.
didn't.
Carroll. Mr.
Oh.
Carroll.
All right.
Okay, what I'm going to do, because I do find that Mr. Carroll does have the right to come to this proceeding and request additional time for resolution. I'm going to set this out 2 weeks to the April 14th docket. So Mr. Carroll, you will, assuming there has not been resolution, you both will return on April 14 at 9 a.m. What I'm going to ask of you in the interim is that you contact Ms. Winkle's office to arrange whatever resolution to this action you are proposing. If there is not resolution by April 14th, then we will either come back and you can at that time ask to be screened for an attorney, or we'll just proceed on the merits of the case if you choose not to be represented.
Yes, Your Honor. I plan on paying everything today.
On the notice, Mr. Carroll, you should also note that there is a phone number to call to be screened for an attorney in these types of proceedings.
Okay.
Okay.
Yes, ma'am. Yes, Your
Okay.
Honor.
So this
And
map
Your Honor,
will-
if you don't mind, it is free to have an attorney. It is at no cost to you.
Yeah, thank you for including that. That is something that I definitely should add. So Mr. Carroll,
Where did he
that
come
number on for the eviction screening line, if you qualify, you do get that representation free. It is no cost to you if you otherwise qualify.
Yeah, I see it here, the eviction defense screening line.
Yep, so you don't have, let's say you contact Ms. Winkles and resolution isn't reached. You don't have to wait till April 14 to call that number to be screened for an attorney. So thank you, Mr. Kiernan, for adding that. Okay.
Yes,
So
Your Honor.
Yep, so we've reset this to April 14th at 9 a.m.
Yeah, I think so.
Please reach out to Ms. Winkle's office in the interim.
Yes, Your Honor.
Okay, and then quickly, yes, I have a message from the Spanish interpreter.
He looks like his mustache. Yeah. Remember that cartoon? Yeah. That's the worst mustache ever. We call that a moustache. In Jersey, that's called a moustache. All right, let's rock and roll. Let's go to... Oh, we have a Thurston. And when I tell... Oh, wait. No, I'm holding that off. When we hit 200 in the room, I'll go to the day the crayons quit. So right now we'll go to Thurston. And when I tell you the definition of entitlement and snab and snark and gross personality, here it comes. You guys are going to be sick.
On the Zoom call, please.
The court should have in front of it a deferred prosecution petition for Ms. Vigil Garcia.
Aware that you have a warrant out of Pierce County?
Oh my God, no.
Yeah, it looks like from an old,
Dastardly.
it was a DUI, which was amended to reckless
Good
in
one.
2018.
Did I miss a court date?
Yes.
Oh my
and I'll tell you
gosh.
when in a minute here. Looks like it just went out.
Oh my gosh. They didn't tell me when my next court date was supposed to be.
Yeah, it actually was just issued on March 17th. Said you got your drug and alcohol filed. That
Yeah.
was completed. Looks like you were in court on January.
I wonder if they sent it to the wrong address.
I don't know what to tell you other than, so are you in treatment now, ma'am?
I'm trying to find the right place because between Thurston and Pierce County, they want different places. They accept different places, so I have to find a place that will
I think
report
it's
to
state
Thurston and
certified, state certified. That,
yeah.
I mean, we sometimes have people who do things in Pierce County, and
Oh my God,
I assume Pierce
Jal.
County is the same.
Uh,
And the deferred prosecution, that's outlined by statute. Is evaluation here?
We do have a copy, Your Honor. I can forward it.
and this is like the nicest judge on the planet. If you guys watch him, he's been on the show many times. He's the nicest judge in the world, and she gives him such a hard time.
Give me just a minute there, ma'am. I don't see the evaluation is not attached to the petition. Do you know
Look,
if that's
she's like
been
annoyed.
filed?
Forward that to the court.
It might be here. Hang on just a second.
Jal.
Is this from Northwest Resources?
What up, Shawnee boy?
Yeah. Yes, Your Honor.
You know, I don't see any reason why Northwest Resources
warrant.
wouldn't be acceptable to Pierce County. I mean, do you?
It's still there.
Do they have a
So-
location in Tacoma? Because I live in
No,
Tacoma.
they don't have a location, and I mean, if location is the thing, then yeah,
Yeah.
you'll need to figure that out. But I gotta believe there's tons of places. And you live in Lakewood. It looks like. Yeah, I'm
Mhm.
confident there's many places in Lakewood where you can do your program. So you need to get going with that. Do you understand that, ma'am?
Yes.
All right. So. Was Scram ordered in this case? And is that on now?
I would invite the court to inquire of Ms. Vigil Garcia.
Do you have what's known as a Scram device, ma'am? The
No,
thing
I
on
do
your
not.
ankle? Did we ever order to do that? Yeah.
A long time ago, I think.
And was that taken off?
Yeah.
All right. So, so Ms. Garcia, I do see that there is there is an evaluation here. So I'm looking as what's known as a petition for deferred prosecution. Did you review all this with your attorney there? Did you review this with Ms. Collada? Or did
Yes,
you,
Your Honor.
Ms. Gasling, Mr. Gasling?
Miss Collada.
Okay. You understand if you're accepted into a deferred prosecution program, you'll be under the jurisdiction of the court for the next 5 years?
Yes, Your Honor.
Can you understand also that there'll be a number of strict conditions in place in that you're not to have any controlled substances without a valid prescription, you're not to consume any alcohol, you're not to refuse a breath test, have no criminal law violations, comply with all rules and regulations with regard to ignition, interlock device and license, stay out of bars and taverns, and don't drive without license or insurance. Do you understand that?
Yes, Your Honor.
You need to get it. You've already got the evaluation. It's a 2-year program. You need to get going on that. Do you understand that?
Mm-hmm.
And you'll need to successfully complete it. Also attend a DUI victims impact panel. And you understand you're going to be on what's known as supervised probation. And at
Yes,
least you're gonna
sir.
start out on supervised probation where you are gonna have to check in. You're gonna have to, some days, you're gonna have to find your way to get down here. Do you understand that?
To Thurston County?
Yes,
Oh my God.
yes.
Okay.
And so I'm not sure people do it. Lakewood, yeah, it's not, we'd have people on probation from farther away than Lakewood. So you're gonna need to negotiate that somehow. And you're gonna have to contact that probation department within 48 hours of right now. Do you understand that?
Yes, Your Honor.
Okay. Again, prosecution will be deferred for, like, say, 5 years, and then it'll get
Thanks,
dismissed
Pidge.
as long as you complete it successfully. If you
Pidge.
fail in any of these things that I pointed out, you'll be brought back before the court and you agree that there are facts sufficient to find you guilty in the police report. You understand that?
Yes, Your Honor.
So by entering this deferred prosecution, you're giving up your right to a trial, but you also have the opportunity to get this dismissed, address any issues that you're facing. You understand that?
Yes, Your Honor.
And then you need to be financially responsible for the treatment program. And there'll also be some fairly substantial monetary fines as a result of this to the court for the deferred prosecution. Do you understand that?
Yes, Your Honor.
You also agree that you suffer from alcoholism, which resulted in this charge. You recognize that if that alcoholism isn't treated, there will be a reasonable likelihood of additional criminal behavior in the future. Do you understand that?
Yes, Your Honor.
Rio, up next.
Do you have any questions at all about what's happening here today?
You said it 48 hours to get the probation thing going on.
Yeah, yes.
Are they open on the weekends?
That's 48 hours. I mean, 48 business hours. They're not going to be open on Saturday. You
Yeah,
could probably
that's-
call them later this afternoon. And I'll give you the phone number here in a minute. It'll be on this judgment and sentence, but
Okay.
yeah, go ahead. Anything else, ma'am? Anything you'd like to say at this point?
Not at the moment, but thank you.
Mr.
Hate
Denawi?
you.
No, Your Honor, the state recommends that the court go forward with this.
Oh, my crazy life.
Mr. Gasling, do you know anything about this, or was this all handled by Ms. Collada?
Handled by Attorney Collada.
What's her first name, Pina?
What do you think about all this, Ms. Vigil Garcia?
I'm sorry.
I get that I messed up, but the thing is it's this is for just the general population, these circumstances, but I don't think it's all the way fair for everybody's situation, but that's how I feel about it, especially as a
I'm not
single
sure
parent.
exactly what you mean by that. I mean, you're asking for the deferred prosecution. Yeah, what do you mean by that? I mean, deferred prosecution, when someone enters a deferred prosecution, they take the position that, yes,
She stumped him.
I have an alcohol problem. I'm an alcoholic. I need to get this taken care of. If I don't get this taken care of, there's going to be an additional problems in the future. This does constitute a second DUI within a certain time period. If you were pleading guilty or found guilty to this, you'd be looking at some fairly, I don't know what the
He's helping her out so much by doing that deferred prosecution. As a single parent, she's helping her. And all she has to do is complain and say it's not fair that she has to travel. It's like an inconvenience. You're the one who drank and went behind the wheel more than once. Are you kidding me? Oh, if I ever wanted to smack somebody, it's you.
I'm going to find out because we need the BAC, but you're avoiding some fairly substantial jail time as a result of this. And so if you're doing this deferred prosecution just to get out of jail, that doesn't really bode well for success. If you're doing it because you internally recognize, yes, you have a problem you need to deal with, then things would be better. But I'm not sure what you mean when you say, and I thought I heard you say, well, this, for the general population, but maybe it's not fair to me. I'm not sure exactly. Maybe you could explain that to me.
It is fair. It is fair. but it is,
What
it
were you trying to
recommends
tell me?
a lot of time, and money and time and, you know, um,
Exactly, Kim.
but it is
What up,
doable.
Allison Barnes?
Your Honor, I
Steve?
just-
The
it-
regulars
it
are
goes for
trickling
everybody,
in.
but I do believe that Ms. Vigil Garcia is enthusiastic about taking advantage of the opportunity.
Well, she's going to get the opportunity. I'm going to grant the deferred prosecution. I was just confused as to what she meant, and I'm trying to figure that out. We're not. But here's the thing, ma'am. You know, and it looks like, just in looking, I don't know you, I've never met you until that I know you may have appeared in front of me over the course of this case. Frankly, I can't remember at the moment, but just kind of looking over what your record there, it kind of looks like you've been dealing with a fair amount of drama over the years. That fair to
Yes.
say?
Mm-hmm.
Thank you, Steph.
And now here you are, and like I say, this is a second DUI. I kind of think it would be everyone's hope, and frankly, I hope yours, that just making sure that alcohol or any substance is not a part of your life might go a ways toward reducing that drama. And again, I say that without knowing anything about you other than what I see just in front of me and things you've been through and so forth, which has been frankly quite a lot, I think. So I don't know, do you have a response to that, a reaction to that, or am I saying anything that makes sense to you, or am I just kind of out to lunch on this whole deal?
Oh, I agree. And I am going to take advantage of this time to work on my health. And, this isn't just about alcohol. It stems from mental health problems. So I'll take this time out to work on myself.
All right. So I'll grant the deferred prosecution. Prosecution will be deferred for a period of 60 months, 5 years. There'll be a $1,200 probation fee, $43 in court costs, and that'll be it.
This is Washington State.
Not to have any criminal law violations, don't drive without license or insurance, don't consume any alcohol or have any controlled substances without a valid prescription, don't refuse a breath test, stay out of bars and taverns. Any car you drive needs to be equipped with an ignition interlock device. That's important. As per the regulations of the Department of Licensing, you can check through them with what their requirements are. Get a drug and alcohol evaluation, comply whatever's recommended, attend a DUI victims impact panel. And as I said, you're going to start on supervised probation. Do you have something, you can access this judgment and sentence on the district court website, but I can also right now give you the probation telephone number. Do you have something you can write that down with?
Yes.
It's 360.
Okay.
786.
Okay.
5452.
Okay.
And that's it for
Huge
today.
break,
You might want to wait till at least after lunch, but if you do that today, call them this afternoon or call them on Monday. Take care back. Good luck on your deferred prosecution, ma'am.
Oh, sorry. Your Honor, one more question.
Sure.
So because it's like $1,200 to set up the probation, and I don't have that.
No. It's not to set up the probation. That's going to be there. You can make payments on that. That's not something that you have to do that. You can make payments on that over time.
Okay.
You can talk with the probation department about that. No, it's not. Okay. You don't have to pay that to get started. You start right away. And, sometimes it takes people a couple of years to pay that off. And sometimes people can pay it off all at once. And so right now, I think the focus should be on getting yourself in the treatment program and in compliance with that.
Yes, Your Honor.
Good luck, ma'am.
Mods, can you guys help out DK with renewing her membership? She's so loyal. She's been loyal since day one. We got you, Deirdre.
Thank you.
You're welcome.
I'd ask the court to call.
Welcome,
Ray
Joe
on
Punk.
Meta. He's numbers 1, 2, and 3 on the 11 a.m. calendar.
All right, here we go.
And Your Honor,
We
if
hit
I
200.
could just intercede briefly, I'm trying to have a
We hit 200, so we are going to Amarillo the day the crayons quit.
So let's start with Cristobal Cisner.
A lot of mustard.
Hi, good morning. Mr. Cisner. All right, so you are, give me 1 second. You're charged from, you have citations from 2 different dates. It looks like you received on
Flowing locks.
2021 a possession of drug paraphernalia. Fine range on that is $100 to $500 plus court costs. You have the right to plead not guilty as you had before. You want to plead not guilty in order to have time to hire an attorney? Or
Getting his filthy
Okay,
side,
all right.
baby.
On your no contest plea, I will assess fine and court costs in the amount of $581. Give me 1 second. And then deduct jail credit you have, and I'll let you know what the total is on that in a second. On your March 31st, 2023, you're charged with the offense of public intoxication. Fine range on that is $100 to $500 plus court costs. How do you plead on that? Or do you want to plead not guilty in order to have time to hire an attorney or have trial?
No contest.
All right. On your no contest plea, I will, to public intoxication, I will find you guilty, and I'm going to assess fine and court costs with your jail credits taken out of that. Give me 1 moment. You are going to owe, hold on 1 second.
Joe Punk. Grab your memberships, people. It's raining memberships. I don't know what's nicer. The memberships flowing or this guy's hair? Poll time. There's no ketchup in this condiment. It's all mustard. Must be serving hot pretzels and hot dogs tonight. I like ketchup on my hot dog, personally. I don't know.
Give me 1 moment.
While we're waiting, now that I have people all across the country, do people know what Taylor ham is? My crazy life probably knows. Does anyone know what Taylor ham is?
A warrant issued for your arrest, and then you'll be right back where you started. Do you have any questions, sir?
I'm staying here the weekend.
Sir, you just have to know, you as far as our cases, what they're going to do is run you through the system. But as far as our cases go, you've already pled to them, and now I've told you to report by Monday. So you should get out today unless you have anything else holding you. But
No.
just make sure you get a map from him and appear on Monday, okay?
That's downtown, right?
It is downtown. He's going to give you that map, and you just need to come by 2 p.m. Get here about 1:45. Check in with the cashier. If you want to come at 11, we also have an 11 o'clock. But you have to be there. I appreciate it. Okay. Have a good day.
You too.
You can return to your pod. Thanks.
Pork roll, Amanda knows. Okay. Jersey, we call it Taylor ham. Or pork roll. Taylor ham is the company that makes pork roll. In Jersey, you ask for Taylor ham and cheese on a bagel. Or a hard roll.
Okay, Mr. Aaron Cotter? Aaron Cotter?
He was taken back, Judge.
Okay, just now?
Yeah.
Okay, thank you. All right, so how about Joseph Peter Nalum Michael?
Yes.
ma'am.
All right, sir. Hello. Come on forward. Okay, Mr. Michaels, you are charged from, looks like you received a charge on March 30th, 2023 of public intoxication. The fine range on public intoxication is $100 to $500 plus court costs. Do you want to plead not
Welcome, Kelly.
guilty? Okay. How do you plead, sir?
Guilty. If I plead no contest, can I get time to pay it and get out today? Cause I gotta get home, ma'am.
Okay.
I'm not from here. I was waiting on my sister last night. Right before she got there, I got arrested.
Okay, sir. Well,
I'm not from here, ma'am.
I'm sorry to hear that. Well, you know, yes, here, let me tell you what's going to happen. If you plead no contest, would you like to tell me you want to plead no contest, you don't want an attorney, and you don't want a trial? You're waiving your right to that?
Is that the best thing to do?
Well, I think on your if you're guilty, we're going to enter your plea of no contest. What I'll do is I'll assess your fine in court as a 484, give you credit, your jail credit that you've served so far, and then release you to report to come see us. But you have to be guilty in order to plead guilty or no contest.
Okay, if that's what's best for me. If I can leave today and go home, I will pay.
Okay. Well, okay, thanks, sir. Okay, so what we're going to do on your plea of no contest, the public intoxication says fine and court costs of $484, give you credit of $150. So you're going to owe a balance of $334. All
yes,
right?
ma'am. I will pay that.
Okay, sir. So I'm going to release you to report to come see us. Is this all that's holding you there?
Yes, my sister was almost here last night and they arrested me.
Right,
She
you don't.
came from Dallas, ma'am.
Okay,
Now she's
all
got to come back to get me again today.
Okay, all right. Well, listen, all we're gonna do is release you to report. We'll
Do it.
release you on this today, and you'll be owing $330.
Do it, crazy.
You can pay it either at the jail or you can pay it up here. You don't have to come see us on Monday by 2. So if you pay it, you don't have to come into court. But if you don't, you need to come see me by 2 p.m. on Monday. They'll give you a map. All right?
Yes, I will. I'll pay it on the phone. I promise you.
Okay, sir. All right. Well, I appreciate it. All right. Do you have any other questions?
No,
Okay. Well, I wish you the best of luck. All right.
thank you so much.
As soon as they process you out, as long as nothing else is holding you, you'll go. Okay. Thank you.
Thank you so much, ma'am.
Sure, you can return to your pod.
God bless you.
All right. Have a good day.
Judge, how did he plead?
No contest. Thank you.
Let's address this for a minute. Look at Joe Punk's comment, everybody. I'm going to tell you, and everybody who's been following me since day one, Joe, it's not on purpose. Never. It's never on purpose. I swear.
Babas Torres.
Yes.
Okay. So you have, excuse me, from December 3rd, 2022, you were stopped in a Ford Flex on, it's like 3900 block of I-27, received citations, excuse me, for speeding in a construction zone, workers present, and no driver's license and dealer plate violations. Fine range on those are, $1 to $400, $1 to $200 on the no driver's license and no dealer plate violation, and the dealer plate violation. Okay, so do you want to plead not guilty on those in order to have time to hire an attorney or have a trial?
I'm not sure.
Okay, let me explain how it works. So if you plead guilty to these offenses, I'm gonna assess a fine within that range, and then I'm gonna give you your jail credit you've served so far, give you a total, and it looks like your total would be like 1131. And then give you credit for jail time that you served, and then release you to report to us, but you have to be guilty of these to plead guilty or no contest, all right? Or you can plead not guilty and I'll set a bond. Either way, you just tell me how you want to enter your plea,
What's up
sir.
with the Ice Cube shirt, bro?
Do you know?
Where's your smock?
Well, on those charges, the speeding in a constricted zone, I was taking my girlfriend to her job and she was already late. So that's why I was speeding.
Okay. All right, give me 1 second, sir. Hold on a second. Let me look here. How old are you?
18.
18, okay. Okay, you know what, if you have something you want to talk about, maybe we could enter a not guilty plea for you today. I can't hear the evidence of what has happened to you. But we could enter a not guilty plea and set a bond, a PR bond for you on these, meaning you don't have to post any money and you can get out and then release you, and then you're going to come see me as directed on that bond. So if you want to talk about it, instead of pleading today in jail, I think that's what we should do. Does that make sense to you?
Yes.
Okay. Okay. So, to the speeding in a construction zone and all the other ones, would you like to plead not guilty and get a bond?
Yes.
Joe's
All
on
right.
fire.
Okay. So I'm going to set a bond in the amount of $500 surety bond on each one of your cases, and you need to report as directed on that bond, and it should be by 2 p.m. on Monday. Okay, you need to be here to see us. Okay, but make sure you come up here according to the bond.
Okay.
Okay, and if you don't have anything else holding you, they'll process you through on a PR bond. You don't put up money. It just means you are personally responsible, saying you will come to court. If you don't come to court, then the next time, we'll issue a different kind of bond or a warrant. So you have to make sure you come to court, okay?
Night, Ginger.
Yes, it'll be Monday. If there's not, they're gonna run you through the system, see if you have any other holds. If nothing else is holding you, then you'll be here by 2 p.m. on Monday. He's gonna give you a map telling you exactly where we are, but we're next door to the police department.
Okay.
Downtown. Okay? Does that make sense? Any questions?
Do you know when I'm gonna get released?
What they just as long as it takes, nothing else is holding you there, right? You don't have any other charges you know of? Is it just
Yeah, just those. Just those.
okay? So they will process you through, and you'll get out sometime today.
Okay.
The pod officer will be able to tell you. All right. And then, so we'll see you according to your bond. Probably it'll be on Monday, and we can discuss your case then. Okay.
Okay.
All right. All right. Have a good day. You can return down to your pod.
Okay.
Mr. Moo, come forward, please. Mr. Moo. All right, Mr. Moo, can you hear me?
Yes.
All right, sir. You have to come stand for me because I can't see you. Can you do that, please?
Oh, Mr. Moo.
Now, can you move up so I can see? Okay.
Come up there, Moo.
Just a couple steps. Sure good. There you go. That's perfect. All right.
I don't wanna.
So, Mr. Moo, I'm gonna. Oh wait. Do we need to get the interpreter?
He was speaking English a minute ago, Judge.
Okay. Do you understand me?
Yes.
Okay. Great. So, Mr. Moo, you are charged. Let's just talk about your case. You're charged from September 2nd, 2022, with the offense of public intoxication. Fine range on that, $100 to $500 plus court costs. If you plead guilty or no contest today, I'm going to time serve you, meaning you've already served your time in jail. If you want to plead.
That's all we got, Amarillo. Live and die by the red record. Okay, here we go. St. John time. Ding, 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 ding. Main event time. Part 2 of Miss St. John versus my girlfriend, Judge Elizabeth DeSanto. Here we go. Let's do it to it.
I have two matters I have to handle here in the courtroom for a quick moment, and then I will handle Miss St. John. Miss St. John, yep, good morning.
Good morning, Judge.
Here we go with the mic. That's her mic.
All right, and
Her mic is dreadful.
Mr. Jamal, good morning, you're here regarding Mr. Malnowski, and I believe Mr. Malnowski is here in the courtroom. Can we set him up in the, is that Mr. Malnowski? Oh, you're Mr. Malnowski's son. No, Joe.
He has evidence to show.
Oh, okay. Okay, so Mr. Jamal, you're here for with Citibank.
That's correct.
Okay, and Mr. Sassong, which matter are you here on? City of Dearborn. Isn't this supposed to be in person?
Yes, Your Honor. Good morning. I'm here on City of Dearborn, Michigan versus Mark Jones.
Right, and I believe that it was all supposed to be in person today because Mr. Jones has evidence he's presenting. So, did you already receive that?
Our office did not receive any documentation from Mr. Jones prior to today's hearing. No.
Right, that's why I think it was supposed to have been in person today. Can you hear me? And all parties were supposed to have been in person, 1763.
Judge Dad wasn't live today, Tink. Hello, by the way. Yeah, there was no Judge Dad today. I want to fast forward, but I also I don't want you guys to miss when she goes on camera by
Yeah, we're
herself.
supposed to be in person to present all this documentation.
I'm gonna go. All right.
Because it's too voluminous. This is likely going to have to be adjourned so everybody can be in person. Owner
A supplemental money judgment.
before April 10th, plaintiff apply for order evicting the defendant. Partial payment will not prevent
Oh, Miss St. John, you're always lovely. You look fine. Oh, there she goes. Oh, how do I look? Section 8. The blue book. But it's the blue book. She is a nightmare. Imagine being married to her. It's like watching someone at the zoo. Look at her. Look. Oh, God. I can't. Look at that. She's just a train wreck. You know, I usually get people in the comments, they, like, after a video, they're like, how dare you make fun of her? You're a disgusting human being. Not a word about her in the comments. Everybody disliked her. I couldn't believe I wanted to post some stuff about St. John, people calling me disgusting. Not one comment about St. John that they liked her. No one felt bad for her. Nobody called me a chauvinist jerk. Like, nothing. It was amazing. I was waiting for it. And I get some bad comments. Bad. Someone called me disgusting today. I love your channel, but we all know everything before but is a lie. I love your channel, but the way you make fun of people is disgusting. She needed glasses, and how dare you make fun of her because she can't see? I dare you to not get old. Hello, I wear glasses. I'm blind as a bat also. I just don't go on Zoom as a lawyer going like this. It's your own fault. Alright, let's fast forward. Enough of her. She's making me sick. She literally was doing her face for, like, how long?
All right, thank you. And Ms. St. John, your name, please.
Crystal Brooke St. John.
Okay, thank you. Okay. So the court last week adjourned it to today's date because the court has some concerns regarding Ms. St. John's understanding of the proceedings and whatnot. The court had Ms. St. John provide us her contact information, which she came up to the court and did. She gave us her social security number, her address, her business line, her Gmail, her personal cell, her email, I'm sorry, both emails there, her WhatsApp on her tablet and her Kindle, and another email. And a phone number. Or no, that must be the WhatsApp number. Okay. So the court provided all that information, took that information, then sent Ms. St. John the information to Lakeshore Legal Aid. Because when the court sent an email to Lakeshore Legal Aid on Friday, the individual we sent it to was not in the office. So we sent that on Monday. So we had it for her to send on Monday. Or to call. So from the understanding that I have is that Miss St. John contacted and spoke to somebody there, but that person said they weren't able to help you because she was just asking for money. So I don't know that Lakeshore Legal Aid quite got the understanding as to what
Thanks, Lisa.
they were
Thanks, Carrie.
supposed to kind of be assisting with, I think. Ms. Ellison, your thoughts on that?
Your Honor, I am requesting the judgment today. There is no triable issue of fact, Your Honor. We provided the ledger. The rent hasn't been paid. We provided the lease. We provided the deed. We are entitled to judgment, Your Honor.
I don't dispute that you're entitled to judgment, counsel, but as to what I had placed on the record is what I was asking as far as the procedural steps that had been taken thus far.
Yeah, I mean, I heard that sounds like the court has went above and beyond to try to get her some assistance, but I'm not sure that Lakeshore is assisting, which I mean isn't uncommon in certain circumstances, Your Honor. As you know, it's sometimes they're here and sometimes they're not.
Right, and the court did request Lakeshore Legal Aid Zoom in today, but was given, was told that there was a conflict and so they couldn't have anybody Zoom in. And then Ms. St. John, I believe you received a phone call from Ms. Perioski, our landlord-tenant clerk today, correct?
Yes, I did speak to Miss Doreen Perioski this morning.
Okay, and then she provided you with Ms. Lang's phone number, correct? And her direct extension?
Yes, I did leave a message and the extension is 1501.
1505.
Yes, 1505. The phone number is 734-561-4091.
Yes. So
I'm to call Timothy Benson on Monday, and I'm going down to the Social Security office after you see me today. I'm not working today. I'll go back to work Monday.
And where is it you work, ma'am?
I have my own business. I do massage.
And
Over
where do you do
220
that?
watching and under 100 likes.
I go to people's
Tisk,
houses.
tisk, says Joe.
I sometimes rent a room. I keep a ledger
Tisk.
myself. I report to Social Security. I've been my own self-income, and I have Social Security, but they will not let me accept more than $150 a week in tips with the voucher, which I've had since 2016. So that's the most I can make with the voucher is $600 cash per month. And I do. That's what I make.
OnlyFans?
Okay, and ma'am, have you been diagnosed with any mental health disorders?
I have depression. I get bipolar. I've been doing very well. I see a doctor once a month. I just had my wisdom tooth pulled and I had to go to emergency for an infection last week. I'm doing much better. I took 2 weeks off.
Thank you.
Okay, that's good. Okay, so the court's going to indicate the following. The court has reviewed all the documentation in this case. The court has also referred this matter to Lakeshore Legal Aid. So that, because Ms. St. John is continuing to represent herself, and the court had some concerns regarding Ms. St. John's understanding of the proceedings. Do you understand what's happening, Ms. St. John?
Yes.
Memberships. It's raining memberships.
So tell me what's happening.
They want the house and the property. And I paid the rent and I paid the taxes. I was waiting on the title. And then I met the Lennox Property Management through the court. And here we are. Knowing, I mean, the government's supposed to pay their share and I pay my share. So you're supposed to get one check from the government. And I guess they did not fill out the blue booklet, but I guess they wouldn't have to if the title was in my name. So that's what I guess what I'm gonna go to Social Security for after you see me today on our court date, which I will go to Wyandotte on a bicycle. Social Security office.
That was just so random. She's so random. On a bicycle. Oh God! If anybody lives near Wyandotte, please get me video of her on a bicycle going
With
to
the
Wyandotte.
Mishka and the paperwork they sent me to fill out.
What is she showing us?
Okay, well.
Right here.
All
Yesterday.
those members hit the like. Oh,
okay. And what,
there's
what
our
is that?
OnlyFans check.
Social Security Administration, retirement, survivors, and disability insurance.
Okay. Okay, and Ms. Allison, what is the amount that you're requesting?
Your Honor, the amount that I'm requesting is $8,878 plus court costs, Your Honor, of $189. So it's $9,067, Your Honor.
Danny.
And this is for possession only. It's not a money judgment, Your Honor.
Oh, Tommy, if you did.
You're not requesting payment of that
Discord it
amount,
up.
you're just requesting her relocate?
Well, I mean, if she pays it within the statutory time, she can stay, Your Honor, but it, you know, we filed it as a non-payment, so we're not seeking a money judgment, Your Honor.
I see that.
I don't know why they didn't get the payment, but you know, here's my certificate of identity theft protection. It's still $1 million, and that was the, you know, what I'm supposed to do is see the doctor, and it's valid. So that's all I have with Social Security right now. It's $900 to $1,100 a month. Did they do the CERA program, the CERA they were supposed to do?
Well, that.
They're supposed to give money from the government. I don't do that. They're supposed to. They're the property management. I have my son. He mows the lawn. I give him $80 every 2 weeks.
Dang.
He's 18 now. He'll be graduating from Wyandotte. My daughter's 19. She graduated from Wyandotte, but that's why it was the whole property.
Okay. Well, ma'am, it doesn't appear as though you have any valid vouchers. I believe that wasn't there a small amount, counsel, that may have been paid, like a partial payment or something?
In August of 2022, Your Honor, then it was reversed due to non-payment. It was $321, and it was reversed. It was paid on the 3rd. It was reversed on the 4th for insufficient funds.
I also, that was sufficient because that goes straight to my Social Security. That was the actual card I paid for, and I put $200 extra on my prepaid cards, and I type in the router number and the account number, and that was taken off. And I do have each and every one individually wrote down, the PayPal, and I wrote under my son's business, Draven St. John Lawn Care Service. And when my son is too busy at school, I do pay Roberto of El Indios $80 every 2 weeks.
I can't. She topped it. She actually topped part 1. I was busy. I didn't hear the guys. As I'm hearing this for the first time with you. I think the funniest part of everything is when she said, it was sufficient. When she said insufficient funds, it was sufficient. You know, who's ever said sufficient when you bounce a check First of all, who bounced a check? Oh, come on. It was sufficient. Who's Roberto? What's going on? I'm done. I'm done. I think this is my last video. I'm done. Oh. You guys are gonna kill me, you know that, right? Oh, God.
Okay, so here's what the court's going to do. The court has referred this matter to Lakeshore Legal Aid. Ms. Crystal St. John has contacted Lakeshore Legal Aid. And the court does not.
It does. Son of a preacher, man.
Really there isn't any defense that has been established, that's been supported. And the court is going to enter a judgment
You're
in
right.
the amount of $9,067 for plaintiff.
Skippy.
Ms. St. John, you do know that you have the right to have an attorney at your own expense or
Yeah.
low cost or no.
That's all I have with the vouchers, $150 a week and Social Security. I'll go there and see what they can offer me.
And fix your damn mic, St. John. I'm speaking from experience. Welcome,
Right, the
Kim.
court's going to indicate if that amount is not paid on or before, or depending on about on or before April 10th. Plaintiff applied for order evicting the defendant. Partial payment will not prevent the court from issuing order evicting the defendant. No money judgment will be entered at this time. There may be additional money owed if damage to property occurs or rent continues to accrue. Ms. St. John, please make sure you're contacting Lakeshore Legal Aid.
And Monday, I'm calling Tim Benson and I do have the card and I did leave the message, Angela. I did speak with attorney Peter Angelos and he's not able to handle the account. So I will go to Social Security and I will continue. And hopefully they can fill the book out, the booklet, because they, like I said, I paid the extra and they're supposed to be getting a check also. But I'll do the best I can.
Thanks.
Okay.
Okay.
Thank you.
Thank you, Your Honor.
Yeah, on my way.
I'll sign the judgment upon receipt, counsel. Thank you. Have a good day.
Thank you.
Thank you.
All right, thank you. Okay.
Bravo. What a show. She actually did it. All right, here we go. I had to go to big screen for that clap. That was phenomenal. I'm gonna drop a video. I'm gonna just do the whole saga. I'm gonna do part 1 and part 2. And edit it, splice it together. So if you guys haven't seen part 1, you can actually see it. I have my video posted. It's called You Can't Be This Dense. And then that's part 1. Part 2 is The Air Up There. And boy, does she live up to those names. All right. It's not a show without Judge Grandma. She got some attitude tonight. Here we go. It's really not that about her. Listen to the story. Listen to what this guy did. It's really bad.
And recommends a reduction in the bond, 30,000 cash surety, 10%, which is just tether, no contact with the complainant.
And what's up with the closet? Who's this lady? Where's this? She's in her basement. What's going on over there? She's like, I don't know. I mean, it's okay. It looks like a finished basement, and she got her clothes hanging. She likes leopard, but I don't know.
Thank you. What's the current bond?
Current, 30,000 cash.
Oh, you can't have a cash only bond in Michigan? That's against the law.
What about Millie Vanilli over there? Look at behind. Look at the two underneath Judge Thomas. Why do they both have to stand there the whole time? Just because you're both up for court, just because you're on the docket, you both don't have to stand there the entire time. They're both, get in the frame. Get in the camera. Come on. It's Judge Grandma. She's going to yell at us. I want some strawberry candy.
Yeah, 30,000 individual cash.
Okay, well, it has to be at least cash surety, Tim, or at a minimum cash surety.
My information is cash surety, Your Honor.
All right. Mr. Casey?
Yeah, as I mentioned, Mr. Lawrence does have a history. In 2021, he had Haida, another stolen car case. In 2019, he had Haida on an assaultive case. There's been additional contacts. In this case, the allegations are that he hops in the car. Dad's going inside Happy Pizza to pick up some pizza order. Mr. Lawrence hops in the car where the complainant's 4-year-old daughter is, and takes off. Winds up dumping the 4-year-old in a yard where, fortunately, there's some concerned citizens that take her in and look after
It's not
her.
my fault. The only thing you charged him with was still in the case.
Yeah. Just given the facts of the case, they're particularly disturbing. So, but
If he was on Haida in 21, he got closed out already?
he must have done it. There's no violation for him.
When in 21 was he sentenced?
He was sentenced November of 2021 to 2 years probation under Haida. This offense occurred just March 14th.
Sentencing is, yeah, I mean, Madam Clerk, you don't see him with a suppressed on a probation for a November 21 case? Mr. Lawrence, who are you on probation to?
Look at Monica. Is there any way you could put
I didn't
a
hear
different
that.
angle?
I'm not sure which judge it was, Your Honor.
I don't want your
No
walking
surprise
neck.
there.
It might be to you, Judge.
It might be. What was the charge?
There's another stolen car case. Receiving, concealing, stolen. Bridget, okay. What's the blind
Bridget
car?
Hathaway. Well, this was got to go to Bridget Hathaway. One judge per client. All right, so we're going to change the date on this. It's going to be blind drawn to Judge Bridget Hathaway.
Okay, today it's gonna be April 14th.
April the 14th, calendar conference. Judge Bridget Hathaway.
Thank you.
And the bond will, I'll accept the recommendation, 30,000 cash surety, 10% GPS tether.
Thank you.
You're right, Mike Crazy. Yeah, everybody be safe with this weather I hear you guys are getting. Safe, be safe. It's horrible.
Okay.
All set.
Hello?
Next case we're gonna call.
Yes.
So could you believe that? It's crazy what that guy did.
You ready, Judge?
Insane what that guy did. He left a baby on the lawn. Kim Wallace official nerd. Had to get a little grandma on there. All right, here we go. Let's get on to. We got to go back to the well. I'm gonna actually. You know what? I'm gonna show. We haven't had O'Brien on in a while. Judge O'Brien had some interesting defendants on, and then I'm gonna give you our main event. We have two main events. My Discord dropped this one, told me to record. I got the whole thing. It was a motion of enforcement, which is great. It's a really good case. So it's serious, but it's very interesting. So let's go to O'Brien, and then we'll go to motion of enforcement. All right, here we go.
Thank you for the breakout conference, Your Honor. Just have a few
We're
words
on
to
the
say.
record? Okay.
Now this one is awful. What this guy does. When Amy Reiser is in the house, it's Pat. When it's Pat's in the house, when it's Pat's in the house, you know it's serious. She only handles serious stuff. So, did I do it?
You can continue now that we're on the record.
I already said all my good stuff, Your Honor, but I just have a couple words to say about the motion, and then I will ask if the court would please indulge in a breakout room with Mr. Jackson and I. He's an MDOC after the court, so I wouldn't interfere with the docket.
Okay, we can do that.
Your Honor, I filed this motion, and what we're really seeking was information specifically on which parts of the statute were being utilized in the charge specifically. You know, I do understand what the facts allege, but what Mr. Jackson was interested in was which parts of the statute apply to him, because there are several options at different stages in the statute. So that's what he was hoping to find out through filing this motion, Your Honor.
Ms. Reiser.
Thank you, Your Honor. As I indicated in our response to the motion for a bill of particulars, we would ask that the motion be denied. I think the statute is clear, and in this case, in the charging documents, the felony information that has been filed, this is an attempted kidnapping, child enticement, that the defendant did attempt to commit the following listed offense: kidnapping, child enticement, and in that attempt did act towards the commission of that offense, but failed in the perpetration or was prevented in the execution thereof, contrary to MCL 750.92, that he maliciously, forcibly, or fraudulently led, take, or carry away, or decoy, or entice, and in this case, entice a child away under the age of 14 with the intent to detain or conceal the child from its parents or guardians, contrary to MCL 755.350. And that's a date on or about July 9th, 2022 at the location of Pageant Road and/or Clark Road in Washtenaw County. So that information has all specifically been laid out in the complaint and felony information. And furthermore, the minor child did testify at the preliminary exam to the specific things that the defendant said to her, enticing her to get in his vehicle for money. She told him no. He asked again, and she obtained his license plate number and rode away on her bicycle. So I think the specifics are laid out in the information and have been provided further in the voluminous discovery that's been provided, his GPS coordinates during the time of the offense, his statements that he made about the contact with the minor child. So I don't believe that a bill of particulars is necessary or required under the statute. And for those reasons, we would ask that you deny them.
And I agree with Ms. Reiser in this instance. I don't believe that it's required or necessary. And it does appear that the preliminary exam transcript gives you a very good idea of what's being alleged. And then I don't know what the other discovery is that
I don't know what I would do to anyone if anyone did that to my child. I don't know. I would probably be an inmate myself. It's sickening.
has been provided, but I'm sure that gives you even more detail. So the motion is denied. Anything further for today?
It was maliciousness, forcibly or fraudulently. She has to pick one. She can't just take all three.
It's or, Mr. Jackson, it's or.
But
nothing else from the people, Your Honor.
Mr. Bernstein?
Your Honor, I'm asking for a final pretrial date on the April 20th. We have a trial scheduled for April 24th, but I think I would like a check-in on April 20th. I understand the court has an older in custody case scheduled for that same day, so it might be helpful scheduling to have a final pretrial date for myself.
Any objection, Ms. Reiser?
No, Your Honor, I agree that that would be helpful.
Okay, so I'll set that for April 20th at 1:30, and we'll put you and your client in a breakout room, Mr. Bernstein. Thank you.
Thank you, Your Honor.
And I'll prepare a writ for April 20th. And then Sam, will you do a motion? Would you do an order denying the motion for the court?
Yes, I can do that.
Thank you.
Yes, thank you.
Okay, thank you. One moment.
This guy's hysterical. This guy's just a buffoon compared to the last one.
Supplemental number 3, People versus Sean Johnson, 21615 FH.
Michael Dobie for the People.
Order Assistant Public Defender anticipating appointment on behalf of Mr. Johnson.
Good afternoon, Mr. Johnson. Please raise your right hand.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Can you state your name?
Would you ever want your probation officer to be Anita Stuber? No thanks.
For the record, please.
Sean Johnson.
Thank you.
Mr. Johnson, you're before the court on allegations that you violated your probation. The maximum potential penalty is 5 years. You're entitled to a contested evidentiary hearing. Can you afford to hire your own attorney this afternoon?
No.
I'll appoint the public defender to represent you. The allegations are that you were not to use or possess alcoholic beverages. However, on March 14th, you admitted to drinking 2 24-ounce twisted teas, which are 5% alcohol, as reported by the Northfield Township Police. The second allegation is that you were to complete a
O'Brien has never drank a twisted tea, let alone ever seen one. You drank 5 twisted teas.
substance abuse assessment and any necessary program. And on September 26th of last year, you obtained an assessment at Community Corrections, but failed to enroll in the recommended outpatient treatment program. And finally, it's alleged that you were not to engage in any assaultive, abusive, or threatening behavior. However, it's alleged that on March 14th, you were verbally abusive to Sandy Dumas and got in her face, behaving in an intimidating manner. So how are we proceeding, Mr. Overwater?
Yeah, I believe probation has a recommendation that which Mr. Johnson would like to accept. In doing so, I would ask that he plead guilty to counts 1 and 2 and no contest to count 3.
And what is the recommendation?
The recommendation is to reinstate probation, 180 days, scram remote breath, enroll in a substance abuse outpatient program within 30 days.
So, Mr. Johnson, you heard the recommendation. Is that what you want to do?
Please. Thank you.
Have you had sufficient time to consult with counsel about what to do here today?
Yes.
So you understand then that if you admit these allegations or don't contest number 3, that I would treat you as if you were responsible and you wouldn't have an evidentiary hearing.
Correct?
You understand that?
Yes.
Okay. So is it true, sir, that you consumed alcohol on or around March 14th of this year?
Yes, it is.
And did you also fail to follow up on the recommended outpatient treatment program following the assessment?
I was given extra.
Mr. Johnson, did you follow up on it? Did you start treatment?
I was given a time frame.
Mr. Johnson, please did you do the treatment?
Not yet, no.
Okay, that's all you gotta say.
Thank you.
And then as to count 3, would counsel stipulate that the allegation as stated in the warrant request would constitute a sufficient factual basis?
Yes, Your Honor.
Yes, Your Honor.
So then as to count 3, are you not contesting that allegation? And that was regarding Sandy Dumas. You want to plead no contest to that allegation? Okay. Satisfied, counsel?
Yes, Your Honor.
Yes, Your Honor.
And then as to sentencing?
Your Honor, I would ask the court to waive, I would waive a new report. I'd ask the court to proceed to immediate sentencing.
And as to sentencing, Mr. Doby?
I have nothing to add, Your Honor.
Mr. Overwater?
Your Honor, my client is working on the Alternative to Domestic Violence program. Once he's done with, he's going to focus on the substance abuse treatment. Now he's obviously going to do that within 30 days. He's employed. I'd ask the court to sentence my client pursuant to the recommendation of probation. I would also note that I did have an opportunity to speak to the complaining witness, Sandy Dumas, and she had no objection to Mr. Johnson continuing to have contact with her. They reside together. She wants him to come home and work on his sobriety, so she is content with this resolution.
Okay. And then, Mr. Johnson, is there anything you want to tell me before I impose sentence?
No, thank you, Your Honor.
Okay, I'm sorry, I didn't mean to cut you off. Did you want to say?
No, thank you,
Okay.
Your Honor.
Okay. I am going to adopt probation's recommendation and reinstate you on probation with the additional terms that you must be on scram alcohol tether for 180 days, and you must enroll in a substance abuse outpatient program within the next 30 days. You're entitled to file an application for leave to appeal from your conviction and sentence. If you can't afford an attorney, one can be appointed for you for purposes of appeal. However, the request for appointment of appellate counsel must be filed within 42 days of today's sentencing. And how will you transmit that form to Mr. Johnson?
I will email that to him, but the recommendation for probation was a scram remote breathalyzer, not a remote tether.
That's correct.
Scram. Okay, scram remote breathalyzer. And do you want that on before he leaves the jail, or does he report tomorrow for that?
Agent Seibert actually said he can get to the jail today to do the install, so it should happen this afternoon.
Okay, good. So I'll say that he'll be released after that tether is in place.
Again, I don't believe it's
Okay.
a tether, but
Yes.
Oh,
Oh, I do want to say thank you, Mrs. Fields' reactions. A lot of people have been swiping my my videos and kind of finagling them and making them their own. Mrs. Fields, you could take from mine anytime because you gave me the credit. That was very cool. And guys, if you haven't subscribed to her channel yet, it's pretty cool. She's got an old squishy Gardner vibe to it with a little time served mixed in there. It's highly entertaining, and you get to see my videos on there too. No, but definitely I look forward to working with you later on, Mrs. Fields. I definitely appreciate that. So go over to subscribe, tell her Time Served sent you in the comments.
okay.
to clarify
Good
the
luck
record,
to you,
Judge,
Mr. Johnson.
just to clarify, it's not a tether.
Okay. Monitor.
Perfect.
Pardon me?
I think that's correct. I think it's
Scram
similar to a
monitor.
Stoberlink device. Is that correct, Agent Stuber?
It is. It's a remote breath machine, so they'll be set up with all that.
Okay. Got it.
Thank you, Judge.
Uh-huh.
Number 12, People versus Nicholas Tyler, 22674 FH.
All right, here we go. It is
Mike.
It is the main event time. And you know what? The room is building, it's early. So I got a good one for you. Let's go back to the wine.well. What do you think? We go back to wine.well? I got a good one.
Back next week at 9:20 a.m.
And then we are going to the main event.
All right, thank you. And then this is a matter of the state of Michigan versus Ronald Carroll, 22654.
Oh, Ronald Carroll.
And appearance for the people, please.
Hey, good morning, Your Honor. Michael Pizak for the people. And good morning, if it may please the court. Sarah Robinson, P63181 for Mr. Ronald Carroll, who is present via Zoom. He's in Carroll State Hospital.
All right, thank you very much. And Mr. Carroll, can you please state your name for the record?
Ron Carroll.
Okay. And we adjourn this matter to today's date.
Today's date is,
just wait, okay?
And I believe that we set this for a hearing today so that the court based upon its previous finding and order on competency. So there's apparently 3 options for the court. So counsel, what are you requesting of the court?
Judge, Rod, wait till they prompt you, okay?
Judge, did the forensic center do another evaluation?
I want to go to Forensic Center.
Rod, shoot, they're not asking you
On
that.
March 16th.
Wait, your turn.
On March 16th,
Your turn.
there was a communication from MDHHS that indicates.
I don't even say wait your turn to my students in 5th grade. You have to tell a grown man to wait your turn. Like, oh, God. It's sickening.
The second report for an individual order for treatment is in competency and trial in accordance with the Michigan Mental Health Code. The order expires September 27th of 2023. And this court already determined Mr. Carroll to be in competency and trial on June 27th of 2022. And counsel, did you receive a copy of this report?
I did not, Judge. I did not.
Okay, well that would explain why you were unaware of that. So the conclusion, and we'll forward you a copy of this as well, counsel, but I'm going to jump to the conclusion, which indicates based on the preceding information is the opinion of the interdisciplinary treatment team that the patient is not now capable of completing their own defense. Mr. Carroll, please.
Yes.
Mr. Carroll, please stop talking because it's interrupting the record, okay? Thank you.
They say he is capable?
No.
Oh.
No. Is not now capable of participating in their own defense. It is also the opinion of the treatment team that the patient has made progress, and by continuing the current course of treatment, there is a.
If I had some more people to talk to, I could.
Mr. Carroll, stop interrupting, please. There is a substantial probability that this individual will regain the capability of participating in their own defense within the time limit established by the Michigan Mental Health Code, section 330.2034.
I am not mentally ill. I've read that already. My medication isn't working on off days. And I need my sister-in-law to help me with money issues. I want to go down almost. Or something like that. I want some real food, you know. I've had real food all the time.
Judge, I would ask for another 3-month review.
Mr. Carroll?
3-month review.
Okay, hold on, counsel, just one moment.
Go home,
Mr. Carroll.
What?
I understand what you're saying. And based upon the last interview and assessment, this is the conclusion of the recommendation. And so then here's the recommendation.
Who's recommending it? Who's recommending this?
Let the judge talk, Ron.
I am. Who's recommending this?
I will tell you, Dr. Nana Akampong is the Carroll Center staff psychiatrist. And
I don't even know who she is. I need to see her face.
You're aware.
I need to see her face.
I'm going to, Mr. Carroll, I'm going to mute you. Thank you. And so Ms. Robinson, just so you're aware, it says that you were CC'd on this, so I don't know if it, this is back on, in March. We actually, it would have been March 16th is when this was dated. I don't know if that's when it was.
I received a letter, but I didn't receive like an evaluation. I received a letter, but not the full evaluation. I was expecting a full evaluation update. So,
Okay, so this was the same date, so we will forward this to you. You received it like on March 17th, but, so the recommendation is the following. It is also the opinion of the treatment team that if the court concurs with our recommendation that this patient is not currently capable of participating in their own defense, or likely to make progress within the time period allotted, the patient would benefit from a continuing course of treatment at Carroll Center under the current IST order. So, counsel, the court's going to, you're asking this court for a 3-month adjournment?
yeah, another review date, so he.
Shane, Taylor Hammer pork roll.
Okay, so then, what the court will indicate is that the court will, order that Mr. Carroll continue his treatment at Carroll Center. The court is not discharging the patient at this time, and because the patient has been noted to have a substantial probability to regain competency, and the court's not going to order the Carroll Center to petition Mr. Carroll for civil commitment at this time. And so the court will note that the review was held. We're going to send the copy of the report and recommendation and assessment council to you.
For me? No.
And for the April, May, June. Let's do June 15th.
Definitely.
Yes, Judge.
And then counsel, if you'd like to, and we'll do that at 9:30, and if you'd like to prepare an order, the court will sign that order upon receipt.
Yes, Judge.
Okay, and the court will indicate defendant to continue Carroll Center. Bond commissioner continues. Anything else, counsel?
No.
Not for the
Your
people,
Honor.
thank you.
All right, thank you. Okay, Mr. Carroll, I'm going to unmute you now so that it's not interrupting any part of the record. Can you hit unmute, please?
Judge, is Mr. Wright in the courtroom today?
Hold on, Mr. Collins, I'm still on the record on another matter,
Oh.
so please don't interrupt the record. Mr. Carroll, please unmute.
On mute.
Okay, all right, so Mr. Carroll, we're going to see you back on, June, whatever date I just said, 15th.
No, June, why? Why do we have to wait so long? Come on, man, I'm getting out of here.
Okay,
Ron,
thank you.
come on back.
He mic
No,
dropped.
that's okay, that's all right, so we're all set, thank you.
Judge like, nah,
Yep, okay.
no
All
more.
right, have a good day.
Good day.
Yep.
DeSanto never
And this
invites
is the
anybody.
matter of the state of Michigan,
Bye-bye.
Respondent Vinegar, 23406.
Next.
Good morning, Your Honor. Please,
Okay, so here we go with the main event. Our always end it with a nice long one for everybody. wind everybody down. A motion of enforcement.
And are
Here
you the
we
movement in
go.
this motion for enforcement?
Yes.
Who's the respondent?
Casey Bolding?
And can you identify her here on the screen today?
Yes.
And can you tell the court the name of your children who are the subject of this suit?
Ty Bolding and Tori Bolding,
How old are they?
7 and 12.
And Pam, could you pull up Exhibit 1? Bria, I'm going to show you our summary of requested relief.
Can I share the screen, Judge?
Go ahead.
Thank you. Oh, not that.
Grant, did you work with our office to prepare this document?
Yes.
And if I asked you about each and every one of these requests, would your testimony be the same as what's on our summary of requested relief?
Yes.
I'll offer Exhibit 1.
Any objections?
No objection, Your Honor.
Exhibit 1 is admitted.
Thank you. Pam, you can pull it down. And Pam, can you pull up Exhibit 2? Mr. Bolding, I'm going to be showing you your final decree of divorce. And is this the decree that you're seeking to enforce today?
Yes.
And Pam, I believe it's page 24 is where the signatures are. And is this document signed by both you and Ms. Bolding?
Yes.
And I'll offer Exhibit 2.
Any objection?
No objections, Your Honor.
Exhibit 2 is admitted.
And Mr. Bolding, are you alleging that Ms. Bolding has violated the terms for possession and access in your decree?
Yes.
And I'll ask the court to take judicial notice of our motion for enforcement.
I will do so.
Are you familiar with the provisions in your decree regarding alternative weekend possession?
Yes. I got to give 14 days of notice, and then I get 1 weekend a month from Friday at 6 to Sunday at 6.
And are you familiar with the provisions in your decree regarding extended summer possession?
Yes. Without any notice, I get June 15th to July 27th.
And does Ms. Bolding have a weekend in between there, or how does that work?
She's allowed to have one if she requests it.
Okay. And are you alleging that those are the provisions Ms. Bolding has violated?
Yes.
And when was your decree entered?
August of 2018.
And what violation occurred regarding possession of Ty and Tori on July 2nd of 2020? And if I need to pull up the motion, I can.
Well, she didn't. She had them from the 26th of June to the 2nd of July. And she was supposed to return them for the rest of my summer, but she didn't give them back.
So y'all had communicated that she would have a weekend in between your summer possession?
Yeah.
And then she didn't return the children to you for the rest of your summer?
No, ma'am.
And I'm going to pull up Exhibit 3. And do you recognize this?
Yes.
Are these messages between you and Ms. Bolding?
Yes.
And how do you know that?
Because that's the number I text her.
And what is the date of this message?
June 9th.
Are these true and correct copies of your text messages?
Yes.
Have they been altered in any way?
No.
I'll offer Exhibit 3.
Any objection?
No objection, Your Honor.
Exhibit 3 is admitted.
And what's being conveyed in these text messages, Mr. Bolding?
That she'll keep them from the 26th to the 2nd because we had plans for the 4th of July.
And did you lose 25 days of your extended summer possession
Yes.
after Ms. Bolding and you had your agreement?
Yes.
Was this in violation of your decree of divorce?
Yes.
What violation of possession of Ty and Tori occurred on September 9th, 2022?
She didn't give them to me for my weekend visitation.
And did you give Ms. Bolding notice of the weekend you selected to exercise for the decree?
Yes.
Where's y'all's exchange location?
Wichita Falls.
And did you travel to that exchange location?
Yes,
What time did you arrive?
6 o'clock.
Is that on time?
Yes, ma'am. That's the time.
And how long did you wait for the children to be dropped off?
At least 30 minutes.
And Miss Bolding never arrived, did she?
No.
That was in violation of your decree as well.
Yes, ma'am.
And what happened on October 7th of 2022?
Same thing. She didn't give me the kids for my weekend.
And you had given her notice of your weekend for the decree?
Yes, ma'am.
Did you travel to the exchange location again?
Yes, ma'am.
Did you timely arrive?
Yes, ma'am.
And how long did you wait for the children on that occasion?
At least 30 minutes.
And she never arrived.
No.
And what happened on November 4th, 2022?
She just basically denied me that one.
And had you given her notice of the weekend you selected?
Yes.
And how did Miss Bolding respond?
She emailed and just basically said she's not coming.
And I'm going to show you Exhibit 4. And do you recognize this?
Yes.
Is this an email exchange between you and Miss Bolding?
Yes.
How do you know that?
Because that's her email address.
And what's the date of this email chain?
November 4th.
Is it a true and correct copy?
Yes.
Has it been altered in any way?
No.
I'll offer Exhibit 3.
Any objection?
Yes, Your Honor, I would like to object to hearsay statements.
Your Honor, these are admissions by party.
Your Honor, I
Overruled.
see.
Go ahead. Is there someone other than the parties in here?
Yes, Your Honor, Christopher Lambert.
He's an attorney with our firm, Your Honor. He's just CC'd.
Okay. What exhibit number is this?
This is 3.
This one says 4.
Oh, I'm so sorry.
Okay. The objection is overruled. Exhibit 4 is admitted.
And does this email chain contain the events you just described, Mr. Bolding?
Yes.
And so yet again, Ms. Bolding violated your decree.
Yes, ma'am.
And Ms. Bolding's answer to our enforcement, she claims the children are abused and states that's her reasoning for withholding the children. Is that correct?
Yes.
And Ms. Bolding actually filed a temporary restraining order in September of 2022, didn't she?
Yes, she did.
And she pled allegations of abuse in that restraining order, didn't she?
Yes.
And what was the result of that restraining order?
It was denied.
And were those the same allegations that she's alleging today?
Yes.
Although the court denied Ms. Bolding's motion for a temporary restraining order, she continues to deny you possession.
Yes.
And Ms. Bolding openly admitted our last hearing that she denies you possession.
Yes.
She admitted she doesn't follow the court's orders.
Yes, ma'am.
Can you tell the court why you're bringing this enforcement?
I'm bringing it because from September to December, almost 4 months, I didn't see my children at all, and they're young, and it's important to see them, and we missed them, and I just don't want it to happen again where she doesn't feel like giving me the children. She won't. I want her to be able to, her to follow the decree and me to see my children when I'm supposed to, not have to worry if I'm going to be able to pick them up or not.
And you're not here out of spite or anger towards Ms. Bolding, are you?
No.
Just for what's in the best interest of your children?
Yes, ma'am.
And what are you asking the court to do today?
Just to enforce the divorce decree.
And are you asking that the court find Ms. Bolding in contempt?
Yes.
Are you asking that the court jail or fine her?
Yes.
And are you asking for attorney's fees?
Yes.
I'll pass the witness, Your Honor.
Okay. Go ahead, Mr. Jordan.
Good morning, Mr. Bowden. How are you doing today?
Good. How are you?
Great. So I see that you are here for an enforcement hearing, and you would like the respondent here to be jailed, fined, and held in contempt. Is that correct?
Yes.
And this is based on allegations of her violating the order that was issued in this court. Is that correct?
Yes.
All right. So let's go back to these alleged violations. All right. And before we touch on them specifically, I want to ask: did Ms. Catherine Bowden, ever bring to your attention that the children were being abused in your home?
Your Honor, I'm going to object to relevance. The TRO had the same allegations and it was denied.
And you're an hour.
Overruled. You may answer the question.
Yes.
All right. And when she brought this to your attention, what was your response?
It's not true.
Okay, so your response was that it never happened, correct?
It is not true, yes.
All right, how often did she bring this concern to your attention?
One time.
One time? Okay. So let's go back to the first alleged violation. If you recall, what day or what instance did that violation occur?
July 2nd, 2020.
All right, and what happened for that July 2nd, 2020 issue?
She did not return the children back to me for the rest of my summer.
All right, let's take a look back at, I believe it was labeled Exhibit 2. This is a text message chain between you and Ms. Bowden, is that correct?
Yes.
If I may share my screen to include this, Your Honor.
You should be able to.
Let's see. Are you able to see what's marked, I believe, as Exhibit 2 for?
Yes, the text
moving?
message.
All right, perfect. So in this text message, it states that from the 26th to the 3rd, and if I'm correct, you stated that you needed the children returned on the 2nd. Is that right?
Yes.
And then you asked for her to please text Jamie so that way she can work it out with Jamie regarding the possession access to the children. Is that correct?
Yes.
All right. And so her response was that I text and I haven't heard back. Is that correct?
Yes.
All right. So in that message, does it show anywhere where Ms. Bowden denied you access on the 2nd of July?
No, this was before she picked them up. This was in June.
Okay, do you have any proof? Because we didn't see any information that was admitted showing that she had denied access to you July the 2nd.
Can you scroll it down? I don't know what the other one shows.
This is June the
same thing.
No, this is June the 10th. This is a month before.
Okay. Yeah, this is June 9th. So she didn't give me access because she didn't give me the kids back. I didn't get them back.
Okay. All right. But there's no text exchange showing that you all agreed that she would give you back the children on July 2nd, is there?
Her cool was her agreeing.
Okay, but after that you referenced, please text Jamie, and she stated, I text, haven't heard anything back. Is that correct? Am I reading this correctly?
Yes, but I think the one below, see it says June 10th. I think the one below has more information. I'm not sure exactly.
Okay.
I think that's her talking to Jamie.
Okay.
Confirming the dates.
All right, let's move forward to the second violation. This occurred September the 9th. Is that correct?
Yes.
All right, and so tell me the facts regarding this alleged violation.
I sent her a text saying I'm going to pick him up on the 9th. It was my son's birthday, and she didn't show up for my weekend visitation.
And when did you text her that you was going to pick him up on the 9th?
At least 14 days prior. I always give my 14-day notice.
Can you identify the date?
I cannot. No, I don't always do it exactly 14 days. I can give at least 14 days notice to guarantee that I can get my visitation. But that was a date that was agreed upon.
But it's correct that you can identify the date that you provided this notice. Is that correct?
No.
Okay. All right. And then so September the 9th came, and this was your time for possession. Did you have any communications with Ms. Bowden prior to that?
Yes.
All right. And did Ms. Bowden tell you any concerns that she had with the children being in your home?
Yes, but I told her it wasn't true, and I still had my visitation.
All right. And so these concerns, did Ms. Bowden state that the children were being abused in your home?
They're not abused in my home, but she did try to say that.
Okay, so let me re-ask the question, and it's a yes or no answer. Those communications, did Ms. Bowden disclose to you that the children were being abused in your home?
Yes.
All right. And your response was it never happened. Is that correct?
Yeah, unfounded.
Okay. All right. And so based on that, Ms. Bowden decided that it was in her best interest to protect the children from that abuse. Did she tell you that?
Yes, but there was no abuse, and I have the right to my children on a 1 week a month. That's why.
All right. I'm going to object, non-responsive. I'll move forward. Let's go to the third allegation, this third alleged violation. Do you recall the date that this occurred on?
I want to say it was in October. It was whatever date I picked for October. I'm not sure exactly what weekend it was.
So at this time, you don't recall the date.
It was October.
October has 31 days in it. You don't recall the date that you selected for visitation?
No, I only request 1 weekend a month. I don't know exactly the weekend. It's not exactly the first, third, fifth like it normally be. It's whatever weekend I choose to put the 14-day notice.
But you don't recall that weekend you
Your
chose?
Honor, asked and answered. He doesn't know the exact date.
It was
Sustained.
October for my
Sustained.
October.
Mr. Bolding, when there's an objection, you have to wait for me to make a ruling.
Yes, ma'am, sorry.
I am going to sustain the objection, so don't continue to answer the question. Mr. Jordan's going to ask you a new one.
All right, Mr. Bowden, prior to this date, did Ms. Bowden communicate to you her concerns yet again regarding the abuse in your home?
No, I have, it was the same one. I hadn't seen him since August, so nothing happened. It's the same. She didn't communicate anything. She just didn't show up. She stood on the same, saying no.
Okay, and then November the 4th, which is the 4th alleged violation. Again, you claim that you never received possession of the children. Is that correct?
Correct.
And again, did Ms. Bowden communicate to you her concerns regarding the abuse of the children in your home?
Yes.
All right, thank you. Now, considering all of this, at the end of the day, you disagree that abuse occurred in your home. Is that correct?
Yes.
All right. And because of that, you will never acknowledge or protect the children from abuse because it doesn't exist. Is that correct?
I would protect them.
Let me rephrase the question. There's nothing that you will do now to protect the children from abuse in your home because it doesn't exist. Is that correct?
Incorrect.
Do you truly care about the children's best interest?
Yes.
Have you asked the children regarding the abuse in the home?
Yes.
And have you acknowledged that the abuse exists?
No, it's not. It does not exist. I don't know how to answer that differently.
Okay. All right. No further questions, John. I'll pass the witness.
Just briefly, Your Honor. Mr. Bolding, if you had a calendar in front of you, would you be able to give the dates you gave notice?
Yeah, I could probably go through my text messages and see, or the emails that I sent. I just don't know the exact dates.
And Ms. Bolding withheld your children in violation of the decree all the way from September till Christmas, correct?
Yes, until the judge allowed me to have them back. Yes.
Thank you. Nothing further.
You and I
This
would like
witness.
a quick redirect as well.
Go ahead.
Mr. Bowden, do you have any proof that you had no possession or access to your children for the time period just stated?
Yes.
And has that proof been offered into court today as evidence?
The email, she said flat out she wasn't coming. And
I'm sorry.
I
I'm gonna
don't know.
object to non-responsive.
Okay.
Wait. Y'all are talking on top of each other. I need you to pause until one is finished before the next one starts talking so that I can get an accurate record, please.
Thank you, Tammy. All right, gentlemen, I want you to move on.
All right. No further questions, Jenna.
All right, call your next witness, Ms. Downing.
I just have myself on attorney's fees, Your Honor.
Okay, go ahead and raise your right hand. Do you swear or affirm the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead.
My name's Kaylee Downing. I'm an associate with the law firm Orsinger, Nelson, Downing, and Anderson. I've been licensed in the state of Texas to practice since November 2021. A partner involved in this matter is Holly Barrett. Holly Barrett is board certified in family law. The other associate involved in this matter was Christopher Lambert. Pam, could you pull up Exhibit 7? I'm offering Exhibit 7, which are copies of our CVs as summaries of our professional credentials.
Any objection?
Yes, Your Honor, I would like to object to authentication.
What's the exhibit number here?
It should be 7 is the CVs.
Let's see. I am not seeing it. Is it still being shared?
I think it's trying to be pulled up. Pam, that's 5 that you've got up. It's 7.
Oh, I'm sorry. Let me
I
just.
went out of order.
It's okay. I don't know why I can't. There we go. There we go. Sorry.
I'm offering Exhibit 7.
Exhibit 7 is admitted.
Mr. Bolding signed an employment agreement with our law firm. Our attorney, paralegal, and hourly rates are set forth in the document. You pull up the employment agreement, Pam, it's 8. Going to offer our employment agreement.
Which exhibit number is this?
This is 8.
Here it is. Exhibit 8 is admitted.
And PM, if you could pull up Exhibit 5. I've created an attorney fee summary. It summarizes the fees incurred solely with this motion and anticipated through today. The attorney fee summary summarizes our billing statements as well. Is there any objection to 5?
Exhibit 5 is admitted.
I'm also going to offer our billing statements, which are in redacted form in Exhibit 6. We've redacted everything out of them that doesn't pertain to the enforcement.
Well, shoot. Don't know why I can't. Can you, I don't know why. Hold on. Can you see that?
I can't.
I don't know why it's not. Sharing.
Yeah, one, it keeps just bringing up the summary.
Just gonna get rid of that. It's too many.
Oh, there they are.
Okay, good. Sorry about that.
I'm offering Exhibit 6.
Exhibit 6 is admitted.
The fees represent the time expended working to prepare for the motion for enforcement, the filing of this motion, and the presentment of the motion today. Based on my experience and the novelty of this issue, I believe that the fees incurred are both reasonable and for necessary work. I think the amount charged is consistent with fees customarily charged in Baylor County by attorneys with similar experience as myself. I think the amount reflected in our fee summary is accurately reflective of our fees incurred, which could have simply been avoided had Ms. Bolding followed the party's decree of divorce. We ask for attorney's fees in the amount set forth in our fee summary in the amount of $5,572.50.
Do you have any questions for the witness, Mr. Jordan?
No, Your Honor.
Okay. Any other witnesses, Ms. Downing?
No, Your Honor.
Okay, go ahead and call your first witness, Mr. Jordan.
Thank you, Your Honor. I would like to call Ms. Casey Catherine Bowden.
Okay, go ahead. She's already been sworn in.
Good morning, Ms. Bowden. How are you doing today?
I'm good. How are you?
Good, good. We're just gonna jump right to the chase. All right, we're gonna talk about the abuse your children endured. All right. Are you familiar with Miss Jamie Bowden?
Somewhat, yes.
How are you familiar with her?
She's my kid's stepmother.
All right. And where does she reside?
In Melissa, Texas.
All right. And whom does she reside with?
Their father, Brant Bolding, her children, and the children they share together.
All right. Has your children involved in this case ever expressed any concerns regarding being abused by Jamie?
Yes.
Your Honor, I'm going to object. This isn't supported by their pleadings. The only thing they've alleged in their answer is that Mr. Bolding is guilty of abusing the children.
Your Honor, I would respond to that. This has been alleged. In addition, in our temporary orders, this was addressed in full. And regarding the confirming or speaking with the children, the interview of the children has also expressed their concerns to the court as well.
Your Honor, they didn't plead for it.
Okay. Let me pull up the pleadings.
And Your Honor, I would also like to state that this is in response to why we are effectively responding to the allegations of violating the orders. And in doing so, we have to provide a reason, a basis behind in response.
Let me take a look at your answer. Here we go.
Your Honor, if you are looking at the response for our enforcement, it's in the defense section. It's actually the first sentence states that the children were verbally and mentally abused.
I don't believe it said by Jamie, though. I thought it said by respondent.
Okay, so I'm seeing this pro se answer that was filed on November 29th. Is that the only responsive pleading?
I believe
No, Your
opposing
Honor.
counsel filed an amended answer.
So I filed, yes, an answer for the motion for enforcement of possession and access. And that was filed on January the 13th, if I'm not mistaken.
Okay, here it is. It just says the children were verbally and mentally abused. It doesn't say specifically who did it. So
Who?
you can go ahead.
All right, thank you, Your Honor. Miss Jamie, I'm sorry. Miss Bowden, Miss Catherine Bowden, will you please, let me re-ask the question, all right? Did they ever express to you that they did not, first, have the children ever expressed to you that they were concerned?
Stephanie, thank you so much. ×3 with the memberships. Thank you so much.
All right, and how are you informed?
The children disclosed to me after.
Objection, Your Honor, hearsay.
Your Honor, this is not a hearsay statement. She's not saying what the children disclosed. She's stating what happened.
I'll allow it.
The children disclosed their experiences to me after their August visitation. August 14th, the Sunday I got them back, is the day that I learned what was going on.
And from their behaviors, you could tell that they had in fact been abused, correct?
Yes.
All right. Did you bring these concerns to Brent?
Yes.
And what was his response?
Never happened. That's what he said.
Okay. All right. Now, did this concern you?
Yes.
And why did it?
Because he's their father, and when he has them, he has them. He spends time with them. He's there with them most of the time that he has them on the weekends, and he's there. He sees it. He's with them. So the fact that there's absolutely no, even him, there's not even a discussion. There's not, okay, well, what did they say? Well, how? There's none of this back. There's no back and forth about it. It's just, nope, you're lying. It never happened. So.
Now, did his response make you feel that he would never do anything in this situation to protect them from this abuse?
Yes.
Objection, calls for speculation.
Overruled.
All right. In this same instance, based on that response, did you feel comfortable in allowing him visitation and access to the children?
No.
And why not?
Because when either parent is brought information like this, there should at least be some sort of back and forth discussion about what is happening, what with our kids that we share together, and there wasn't. There was just a shutdown. You're a liar. Never happened. You're forcing the kids to say these things. And so there's just.
Okay. Now let's talk about Miss Jamie. You're familiar with her, correct?
Yes.
How long have you known her?
I want to say since 2018, I believe, is when I sort of started communicating with her.
Now, is it in her character to be abusive, verbally abusive?
Yes, based on the history.
Objection, lacks personal knowledge.
Your Honor, she's definitely speaking from her personal knowledge of her. I asked if she
Okay,
knew.
rephrase the question.
Based on your experiences with Miss Jamie Bowden, is she or is it of her character to be abusive?
Yes.
All right. And how do you know this?
Based on our experience from 2020, and one experience from 2019 where they refused to disclose their address so that I could pick up the kids and essentially just know where my children are staying. I was threatened by her twice with litigation and money, basically. And then that's at the time when I brought it to Brandt's attention, he then backed her up and decided that that's how they wanted to conduct themselves in communication with me, which is when I cut her off and discontinued communication with her. And that's just how she behaves.
Has Miss Jamie Bowden ever personally verbally abused you?
Yes,
All right. And how on how many instances did this happen?
just the 2 times. I
Okay.
didn't allow it past that.
All right. Now, have you ever witnessed her verbally abusing the children?
No,
Have you ever witnessed her verbally abusing Brant?
no.
All right. Now, let's talk about the violations that occurred. All right. It's been alleged that there's been 4 alleged violations that have occurred. The first occurring in the summer of 2021. Do you recall that?
The summer of 2020. Yes.
2020. My apologies. And that summer, what happened?
That summer was when everything locked down. I was working at the nursing home. School let out in April. They picked the children up on April 16th. And we didn't really know what was going to happen because it was lockdown. Nobody knew what was going to happen. So the basic plan was, hey, if you want to come get the kids, you can. They've stopped school. We can just work through it, play it by ear. They were for that. They were fine until those messages that they admitted where we wanted to see the kids for about a week. And we verbally agreed that I would pick the kids up at their home and drop them off at their home, which was our second run-in with the refusal to provide their address. It was a couple of days before I was supposed to pick them up. I was told that, oh, you're not coming to the house.
Are you gonna object to the narrative at this point?
I have the messages in my.
Okay,
You can read them.
Ms. Bolding,
Sorry.
if there's an objection, you have to wait for my ruling. Okay. So a narrative is when you answer the question, but then you continue to go. So I am going to sustain that objection. So wait for Mr. Jordan to ask you a new question and then try to keep your response to just the question he asked. Okay, go ahead, Mr. Jordan.
Yes, Your Honor. So as you were saying, Ms. Bowden, there was a lockdown and essentially there was some miscommunication regarding the possession. Is that correct?
Yes.
Now, the messages that were admitted into this court, do those messages summarize the entire conversation that was had regarding the possession access to the children?
No, that was the middle of the middle of our conversation.
All right. Now, at the end of that conversation, what was the conclusion of the possession and access? What did you all decide on?
At the end of the conversation, they refused to provide their address, and I would meet them at Buc-ee's in Melissa, and they would take me to court if I didn't do that.
Okay, gotcha. And before we get to that, one thing that I forgot to ask, notice, at what point did he or did you all decide on the final date of providing the children for this possession and access drop-off period?
What, on the messages for me to have them?
Let me rephrase the question.
Yeah, that was confusing.
When you all decided and made the final plan of where to pick up and how, when did that happen?
That plan happened June, I want to say maybe the second week of June.
Okay. Do you
Probably
believe that was
after those messages that after the 10th?
Do you believe that he provided the proper 14 days notice of identifying his summer visitation?
No.
Okay, thank you. All right, let's move on to the second violation. This happened in September. I believe it was September the 9th. Do you recall this date?
I do.
All right. Do you recall not having or not providing the children to Brent to have possession?
I do.
All right. And why did this happen?
That was during our CPS investigation. I have messages to him from the 6th after he canceled 2 mediation appointments with the CPS investigators and all the guardians involved.
So the purpose of your denial was because a pending CPS investigation was ongoing?
Not necessarily. It was because there was, because he refused to cooperate, refused to mediate beforehand. I didn't feel that they were safe, I felt that it would continue.
What was the CPS investigation regarding?
Regarding the psychological, emotional, and mental abuse of the kids.
Abuse from who?
From Jamie.
Okay, let's move on to the third violation. This happened in October. I believe it was October the 7th. Do you recall that date?
I do.
All right, do you recall not providing the children to Mr. Brent?
I do.
All right, and why did this happen?
Same reason, refusing to acknowledge what was happening, to even discuss it or accommodate for the kids. There was nothing, there was no back and forth between the parents.
Okay, and then the fourth violation, this happened in November. I believe it was November the 4th. Do you recall this date?
I do.
All right, and why do you recall not providing the children to Brent for access?
I do.
And why did this happen?
In the entirety of the email chain that they provided, I did offer to have him come see the kids because that's what they asked, if he would come to town and see them. He refused to do that. I explained again that the safety and the concerns for the kids' well-being were the top priority. I explained it to the attorneys that were CC'd. I emailed with Mr. Christopher Lambert back and forth, and I explained to him as well that this is, top priority is the safety of the kids. And, the best I could do was ask him to come to the kids as they asked me to do. That was all I could offer.
Okay. So for violations 1, 2, 3, and 4, and let me recall those dates. This was the summer of 2020, September the 9th, October the 7th, and November the 4th. Do you believe that Mr. Brent provided the proper notice for those visitation periods?
I believe for the October and November he did. I'm not sure on the September one.
Okay. All right. And is it your statement today that at all times relevant, you were focusing on the best interest of the children?
Yes.
And in doing so, you were concerned that they would continue to be subjected to psychological and mental abuse?
Yes.
And this abuse would have occurred by Jamie in the household of Brent Bowden. Is that correct?
Yes.
All right. Do you recall being ordered to take a parenting class by this court?
Yes.
Did you complete that parenting class?
Section relevance.
How is it relevant, Mr. Jordan?
Your Honor, because this speaks to her ability to provide for the children and ensure that Mr. Brent and his spouse also provides for the children based on the parenting class. It speaks directly to their ability to care and provide the best interests of the children.
Your Honor, the issue.
I'm going to sustain the objection.
All right. Ms. Bowden, are you confident to this day that that Ms. Jamie Bowden will refrain from abusing the children?
Not entirely.
And why is that?
I feel that once everything is settled and all the dust is settled, something will happen. Something will snap and it will happen again.
And when you say it will happen again, are you referring to Jamie's actions will become abusive again?
Yes.
Do you believe that her actions of abuse have stopped temporarily?
Temporarily, yes.
All right. Did you hire me to be your attorney throughout this hearing?
Yes.
All right. And did you sign a contract stating that?
Yes.
At this time, Your Honor, I have no further questions for the witness.
Okay, go ahead and ask your questions, Ms. Downing.
Case 20, we didn't.
Objection, non-responsive. You don't think you need to comply with your decree? It's a yes or no question.
Yes.
At our temporary orders hearing in December, you openly stated you don't follow the decree.
Sure.
You stated that. Is that a yes?
Yes.
And even after the court denied your temporary restraining order, you continue to deny him access.
Yes.
Because you didn't put on any evidence of abuse, the court denied your restraining order.
No.
Your Honor, I'm going to object to asked and answered.
Mark with the dono.
Yeah, let's go ahead and move on. I'll sustain that objection.
Ms. Boulding, you just testified that Mr. Boulding didn't give you adequate notice of the July possession, correct?
In 2020?
Yes.
No, he didn't.
Ms. Boulding, that was a extended summer possession. The 14 days notice doesn't apply.
Mayor.
We agreed that he would pick them up April 16th. He had them from April 16th until June 24th.
And you didn't return the children to him after your weekend in between his extended summer possession?
No,
So you violated the decree.
no,
Ma'am, you didn't return the children.
Your Honor, I'm gonna object to asked and answered.
Sustained.
Ms. Bolding, you failed to deliver the children on September 9th, correct?
yes,
You failed to deliver the children on numerous occasions.
3 more. No, 2 more, October and November.
Ms. Bolding, are you going to continue to deny, or are you going to continue to deny Mr. Bolding's access to the children?
No,
I have no further questions, Your Honor.
Any follow-up, Mr. Jordan?
No, Your Honor.
Okay, any other witnesses for your side?
Yes, Your Honor, I would like to call myself for attorney's fees.
Sure. Okay, go ahead and raise your right hand. Do you swear or affirm the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, go ahead.
All right. My name is Jasmine Jordan. I'm the partner for the law office of Judge Jordan. I'm a licensed attorney in the state of Texas. I've been licensed for approximately 5 years and have worked approximately 10 hours on this enforcement hearing proceeding today, billing at the rate of $175, which is standard or custom to the attorney with similar experience and expertise in this county and counties contiguous to it. The nature of my representation of Ms. Catherine Bowden included investigating, researching, and confirming the allegations of abuse as it relates to the safety and welfare of the children involved. Considering the complexity of this case, an attorney with similar experience and hours worked will result in the same or higher rates than what I've charged Ms. Bowden. Consequently, the hours worked and charged on this case are consistent with the prevailing rates in this community. As such, Respondent is requesting that all attorney's fees be paid by moving as a result of this enforcement hearing. Your Honor, I would like to 2023 from 9:15 to 10 a.m. I worked on this case, which included communicating with the client, reviewing record. Client came out to be roughly.
I'm getting you a ruling. So I will reserve my ruling and I will probably get it to you at the first of next week. Your mediation is at what time on Tuesday?
It's on Monday at 1 p.m., Your Honor.
Okay. Okay. I will email the attorneys my ruling. Okay, let's go ahead and go on.
Okay, so she's emailing the ruling. Boo! That's why I put up the poll. Let's who do we believe? Let's put in our vote right now, people. Who do you believe? Mom or dad? Where do you think she's gonna rule? So basically the ruling is gonna be whoever we believe. So let's go. Let's do it. Let's do it to it. Let's do it to it. Oh, 320. The numbers grow the later I stay on. It's unbelievable. But I definitely have to go. Got to spend some QT with my GF. You like those, huh? You like those codes. All right, people. It's been fun. May get a little members only this weekend. May get a little members only. If not, I will see you all. Wait for my post. If I'm going on the weekend, I don't know. If not, I will see you on Monday. I'm gonna try to get in alive this weekend. If not, 100% Monday. I love you all. Thank you for all the super donations. Thank you for all the gifted memberships. Thank you for all the new viewers. Thank you, everybody. It's been real. I love you all. You've been served.